Hello, everyone, and thank you for joining us. My name is Ismail Royer, and I am Director of Islam and Religious Freedom at the Religious Freedom Institute in Washington, D.C. And I also head up RFI's amicus briefs initiative. And we've filed close to 80 amicus briefs so far over the past 2, 3 years. And joining me today is Melissa Moschella. Melissa Moschella is professor of the practice in philosophy at University of Notre Dame's McGrath Institute for Church Life. Her work spans the fields of ethics, political philosophy, and law, and her areas of special expertise include natural law theory, biomedical ethics, and the family, especially parental rights, which we're here to talk about today, as we'll get into. She is the author of To Whom Do Children Belong? Parental Rights, Civic Education, and Children's Autonomy, published by Cambridge University Press in 2016, and Ethics, Politics, and Natural Law, Principles for Human Flourishing, forthcoming in the spring of 2025 from University of Notre Dame Press. Professor Moschella has also published numerous articles in scholarly journals, as well as popular media outlets, including Notre Dame Law Review, the American Journal of Jurisprudence, the Journal of Law and Religion, Bioethics, the Journal of Medical Ethics, the New York Times, USA Today, and the Washington Post. She graduated magna cum laude from Harvard College and received her PhD in political philosophy from Princeton University. Actually, Melissa, that is the career arc I kind of wish I had taken. I'm very jealous of you. It sounds like a wonderful life of scholarship that you've led. And that is great because what we're here to discuss today, and we're going to dive right into it, is the concept of parental rights. And this is a hot topic. It's come up in many different news stories across the country, mostly related to the field of public school education. We've seen controversies erupt in school districts across the country related to questions like curriculum, whether schools have the right to impose curricula that may violate the religious beliefs of parents, and correspondingly, whether parents have the right to pull their children out from the kind of instruction that they believe is aimed at changing their children's beliefs. And then also we have the concept of parental rights coming up in matters like child custody, whether parents, what are the extent of parents' rights to maintain a relationship with their children when there are powerful reasons for the state to be concerned about the welfare of the child, and many other contexts in which parental rights come up. And the reason that the issue of parental rights is so, let's say, controversial and somewhat undefined and waiting for kind of, I think, clarification from the Supreme Court is that there is no constitutional, or at least there is no enumerated or spelled out constitutional amendment saying that there is such a thing as parental rights. At the same time, the Supreme Court has repeatedly over the years acknowledged that that such a right exists. So it's funny because in a lot of the sort of culture war discourse over parental rights, you'll hear some progressives saying that the term parental rights is sort of invented by conservatives, and this, of course, is clearly wrong, but we want to know, why is that wrong? And if we could, understand a little bit better the nature of parental rights. And before we even get to parental rights, we have the question of, because it's alleged that parental rights is a fundamental right, implying that there are certain rights that are so fundamental that they are pre-political. In other words, we have those rights as human beings by default, before government even exists. And so the question comes about is like, what is the origin of those rights? What is the basis of those rights? What are those rights? How do we determine what those rights are? And once we do determine what those rights are, what mechanism is there for vindication or enforcement of those rights, if your particular statutes or political documents like the Constitution don't specifically identify those rights? And so I'm just going to open it up and let you start anywhere you want. But one thing I would, kind of to kind of point you in a direction in this very broad field is maybe to talk a little bit about the philosophical or theological, even if necessary, underpinnings of this entire discussion.
Well, there's a lot there, and
Yes,
yes, we could spend hours just talking about the concept of rights, which, as you know, is a very complex and fraught and debated issue.
indeed.
But I think one of the things that it's important to clarify when we want to talk about rights is that there's nothing magical about the language of rights or about the claim that I have a right. Very often, I think in our contemporary discourse, rights language tends to be used in this almost magical sort of way, right? I simply claim that this is a right, or I claim that this is a fundamental right, and then all of a sudden some special protection is owed to me, as if I
Right,
didn't need to actually justify that claim, right?
right,
And so we end up with a proliferation of rights claims, some of which are genuine, some of which are not, and which have different levels of actual kind of moral or legal force. So we have to kind of disambiguate, clarify all of that. And I think that if properly understood, a right is simply a way of specifying the requirements of justice from the perspective of the beneficiary. So, to take a simple example, um, most people think that it is always unjust to intentionally kill an innocent human being. Now, there's could be debates about that, but let's just say, for the sake of
hmm
argument, that that's true. That it's wrong to intentionally kill an innocent human person. Um, well, that's talking about a relationship of justice, namely that every single person has a duty to every single other person not to intentionally kill that other person, presuming the person is innocent. You can then translate that requirement of justice into a rights claim if you think about it from the perspective of the beneficiary. Who's the
right,
beneficiary of that claim? Every innocent person, right? So every innocent person has a right not to be murdered, basically, right?
right.
And that again is simply a way of articulating a claim about what justice requires.
Does
Now, when
every,
you talk about something like a right against being killed, well, here you're talking about a fundamental moral right, a right that is inviolable,
mhm,
that it is never permissible to break. There are a few, I think very few, rights of that sort.
mhm,
Um, and those rights are inviolable, they are absolute, right? Never um, justly breakable, precisely because they protect fundamental aspects of human well-being or fundamental aspects of the human good. So being that we are bodily beings, right? Our bodily life is a fundamental aspect of our well-being and deserves this kind of absolute protection from intentional harm or destruction, right? Again, just to take one example. But you wanted to get in there, I see.
Yeah, so does every and this is really important. You've kind of described rights or the nature or the essence of rights as sort of beginning or having a corresponding duty. Do all, and again, we're talking here about fundamental rights as opposed to rights created by a contract or a statute or something like that. Do all of these kind of fundamental rights, like the right to life, or one could also identify perhaps property rights. Um, do all of these have corresponding duties, or are there some rights that are just sort of rights that don't also like begin with a duty?
I think every right has to have some form of corresponding duty in
Hmm.
order to be a genuine right. Now, that duty could be what you might call a negative duty, a
Hmm.
duty not to do something or a duty
Yeah.
not to interfere, right? So in the case of the right to life, right, the corresponding duty is this the duty not to kill,
Right.
right?
Right.
In the case of the rights to property, the corresponding duty is the duty not to steal. Now, you could
Sure.
also talk reasonably about what you might call positive rights,
Hmm.
um, which would then be a right to receive some benefit, right? And that would correspond to a positive duty on the
Right.
part of another person. Those rights tend to be less determinate
Hmm.
than the negative rights, precisely because there is a lot more work that needs to be done to specify, okay, well, what does it mean? You can say I have a right to healthcare, I have a right to education, or I have a right to certain positive benefits
Hmm.
that are required for my full flourishing as a human being. But then the
Right.
question is, okay, well, what exactly is entailed in that? What level of healthcare, what level of education, and so
Right.
on. And
Right.
then even more complicated, who has the duty
Right.
to provide those things for me?
Right. Right.
And that I think is going to be different depending on the situation, right? If you're talking about a child, the duty is going to fall primarily to the child's parents. If you're talking
Hmm.
about an adult, the duty will actually fall to the adult, right?
Right.
Who has the obligation to um, feed me, educate me, get me healthcare, and so on? Well,
Right.
primarily, I have that obligation for myself, and because I'm married, also my spouse, um,
Right.
to assist me in doing those things. But because I'm an adult of sound mind and body, right, I'm capable of working to get the resources that I need in order to achieve, um,
Right.
these benefits for myself. There's a role I think for the state here, but I think it's subsidiary, secondary, and kind of providing assistance in those cases where the primary duty
Yeah.
holder, the individual adult or the parent or the spouse or whatever proper,
Hmm.
relationship there is, where that primary duty holder is absent or impaired in some way,
So
then you
is
may
this
need the state to come in a secondary level.
kind of the is this what the Catholic Church has called subsidiarity, where there's am I getting the word right?
Right. Yes.
Yeah, yeah, where there's kind of there are duties that human beings owe to one another that are not primarily to be discharged by the state. They're to be, they fall upon our fellow human beings, or the institutions that that we have. I was thinking as well, I mean, that's an important point because not all rights that exist are necessarily judiciable, So for example, I have the right to, or my mother has the right that I treat her kindly, but she can't take me to court and say, well, he's throwing his socks on the floor, something like that. Right. Okay, so another aspect of what I think we're talking about here, fundamental rights, is that they apply to all human beings. Now, in what form do they apply? What does what does respecting those rights take might differ from context to context, time and place. But in their essence, they apply to all human beings. Is that correct? By default, as human beings, right?
I mean, again, the word fundamental rights, I think, means different things in different contexts.
Okay, yeah.
Um, so I think it means one thing when you're talking about, say, constitutional law,
Okay.
where it means a certain right that deserves a certain level of legal
Right,
protection,
right,
particularly judicial legal
right,
protection. But when you're talking about fundamental rights more broadly in the moral sense, apart from the legal sense, um, then it does tend to mean rights that attach to a person simply because they're a human person,
right,
um, and that's what makes them fundamental. But I think those categories don't entirely overlap, right? The judicial category,
right,
um, and
right.
the more basic moral category.
Right. And we'll get to this in the context of, for example, I'm going to court to try to enforce a right that I claim to have, a fundamental right that I claim to have. A fundamental right in that context is, its origin, its nature, and so on might be different than a fundamental right when I'm talking about rights between neighbors or between husband and wife or between parents and children and that sort of thing, right? Yeah,
Exactly. Yeah. I mean, very, very often at least especially when you're talking about constitutional law
right,
and you're talking about fundamental rights, you're usually talking about rights against the state.
right. That's a
Whereas when
good
you're
point.
speaking more broadly about fundamental rights, you're talking about rights
Yeah,
often in terms of individuals in relation to each other
yeah.
or smaller bodies and groups in relation to each other, not an individual and the state.
That's a really important point. In fact, it kind of makes me realize that I misspoke when I was characterizing the sort of disputes that are arising about parental rights, and one of the sort of hot topics is, and I said whether school districts have the right to require certain curriculum, but I mean, government does not have rights generally, correct? Is that, I mean, it's people that have rights against the government. It's not that the government has a right, you know.
You can think as well about the rights of the political community and the government as representing the
Hmm.
political community and the interests of the political community as a whole.
That's a good point too. Oh,
Yeah.
okay. Well, yeah, that's a very good point. Well, that leads us then to ask the question about the Constitution. When the Constitution was adopted, um, I think it's fair to say that the concept of law and jurisprudence was quite different than what it is today. And this is perhaps just the nature of the way that sort of philosophical, jurisprudential, theological fads come and go. Societies change and language even changes. So what we have to do often in try to understand the Constitution is to understand um, uh, what the under what to understand what the concepts of jurisprudence the framers had and that were current at the time. And so one of those very well-known authorities that existed at the time was Blackstone. And so Blackstone, who and another one would be like Lord Coke, these authors or these scholars or these authorities were well known to the founders. They were well known to the founding generation. Um, and so it has to be the case that that when they adopted the Constitution and so on, that their concept of law was informed by them. And so one of the interesting um, observations of Blackstone is that positive laws or laws that legislatures made up of human beings promulgate, that those laws are only valid insofar as they correspond to natural law or to law that is sort of pre-political or law that exists um, prior to the existence of government itself. I mean, in other words, as human beings ourselves. So, if you could explain, like, what is the relationship between, these kind of fundamental rights, fundamental in the sense that you discussed before, like the right to life and that sort of thing, and the law, capital L, I guess you would say, that is like law as legitimate law, law that sort of human attempts to legislate are supposed to be instantiating. Um, what was this that Blackstone had in mind? And Koch, if you'd like to get into him as well.
I think Blackstone, Koch, and others, I mean, they're working as part of a long tradition of thinking about law and other thinkers in that tradition. You can think about people like John Locke.
Right,
You can also think prior to
Grotius
that,
and
people like Grotius, people like Aquinas, right? It
Yeah.
even goes back and kind of, precursors in thinkers, ancient Greek thinkers, Plato and
Yeah.
Aristotle, and then
Aristotle.
Roman jurists,
Yeah.
Cicero and so on.
Right.
So there's a very long tradition here where the idea is that law is an analogous concept, um, and and what it's talking about fundamentally is some kind of rule, right? Some kind of um, order governing human affairs that is meant to direct us toward the common good, right? Toward what is
Hmm.
genuinely good for us as individuals and in community. And then there's a recognition that when it comes to the organization of human society, that you need some form of political authority with the capacity to make laws in order to establish order and harmonious relationships among people and to direct that society toward the common good, right? So you have an idea of law as bound up with the common good of a community, as established and promulgated by a legitimate authority for the sake of the common good, and um, and then of the political authority also having the power to enforce those laws,
Hmm.
and so to protect the common good in its various dimensions, right? So if you think about the common good, well, what is the common good? Obviously, there's lots of debates about that, right? But but
Right.
but effectively, the common good um, is, if you think about the political common good as a whole, right? Um, it consists in the conditions that enable all of the smaller units that compose society, not just individuals, but families and smaller groups, right, that compose the larger political society. The common good is establishing a set of conditions within which all of those smaller groups can flourish, right, in
Right.
all of their dimensions. And the specific role that political authority has in all of this is um, to set conditions of justice. Now they're not inventing those conditions, right? They're
Hmm.
they're recognizing those conditions, many of which are pre-political, but then they're also specifying a general requirement of justice that could be specified in any number of ways, but that for the sake of order and harmony, there has to be agreement upon in any given political community. So think again about the right to life that we talked about before. Basic principle of natural law: human life is a good that needs to be protected. Some of those protections are going to be absolute, like protections of the innocent against, intentional killing and so on and so forth. Um, Other rights will be less absolute, like, rights that we have to the due care of others to protect our lives, right? Not simply
Right.
to avoid harming us, but to take reasonable precautions to protect our lives. And that's where you get things like, you know, laws against negligence, right? Or about you have to
Right.
clear your sidewalk after a snowstorm within a certain number of days so that people don't slip and fall and break their ankles, right?
Yeah.
So
Yeah.
there are a set of varying degrees of duties there. Some of those are going to be specified pretty directly by what you might call the natural law, the natural moral law accessible
Hmm.
to human reason, like the law against murder. It's basically just a derivation directly from that higher natural moral law.
Right.
Um, but then there are going to be things like traffic laws, right? We need to be prudent in the way that we, um, exercise these dangerous things called called cars and go
Yeah.
about driving them at high speeds and so on. Why?
Yeah.
Again, because human life is a good that needs to be protected, and that's part of the common good.
Mm.
Um, but natural law doesn't tell you exactly how to do that,
Right.
right? So natural law doesn't specify the speed limit on highways should be X, or everybody has to drive on the right side of the road or the left side of the road. Natural law simply says, well, you have to drive with due regard for the protection of human life. And then it's up to political authorities in human laws to specify what that means for their given communities. So that might mean in the US that we agree to drive on the right side of the road. It
Right.
doesn't really matter whether it's right or left, but you have to choose one. And so law coordinates us, right? So that we don't start
Right.
running into each other, with
Yeah.
different people driving on different sides of the roads. And the same
Right.
thing with specifying a speed limit, right? You might have qualms about, whether the speed limit is too high, too low, or whether you need a red light there or a stop sign or nothing, right?
Right.
But there's a legitimate function of civil authority to say, okay, in order to protect human life and health, we are going to specify that general obligation to drive carefully
Right.
with a whole set of traffic laws, right? So that's just one kind of classic example of different ways in which human law relates to the broader natural moral law. It could be direct derivation, like laws
Right.
against murder, but it could also be a determination or specification of a general principle, things like traffic laws or things like tax laws, right? There's a
Right.
general principle indicating that we need to pool funds in order to achieve certain uh, common kind of material needs like infrastructure and police and parks and things like that. And so pooling common funds for these common purposes, it could be done in any number of ways, and the state specifies one way of doing that through tax laws, right? So those are just some examples. So
Right.
a law is just, according to this tradition that
Right.
Blackstone and Koch and others are part
Hmm.
of, a law is just to the extent that it is in accordance with that broader natural moral law,
Hmm.
either directly derived from it or in some way indirectly
Yeah.
um,
Advances it.
specified. Right.
Yeah.
And,
Yeah.
and
Yeah.
that's what indicates that that law is genuinely promoting the common good, which is the purpose of government.
Hmm.
Any law, however, that's directly contrary
Hmm.
to the natural law is on this view faulty as a law, right? It's not
Hmm.
fulfilling the purpose of law. The purpose of law is to promote the common good. Any law that's directly contrary to the natural law is actually going to be contrary to the common good and therefore contrary to the purpose of law. So
Right.
that it could be a duly enacted law. It went through all the proper
Right.
procedures and so on and so forth. So we can recognize it as law in that sense, in that descriptive
Yeah.
sense. But we can also, as Martin Luther King Jr. did, for example, say,
Right.
okay, well, this law, it's a legitimate law in the positive law sense. It's on the books. It's been duly enacted. But like the segregation laws that Martin Luther King Jr. was protesting against, it's a law that is contrary to the natural moral law. And
Hmm.
therefore, it's a law that doesn't actually deserve our full allegiance. And
Right.
and if it's very seriously contrary to the natural law and to the common good, as the segregation laws were, we might even have an obligation to um, to disobey it on purpose,
Right.
precisely to call attention to the injustice of the law. Again, in the same way that Martin Luther King did in his protests against the Jim Crow laws
Uh,
of the
yeah,
time.
there was I remember reading about the Dred Scott decision that there was a Christian newspaper out of New York who ran an editorial saying that anyone who obeys this decision disobeys God. And yeah,
Exactly.
and the dissent it actually argued on the it's they mentioned the dissent, and one of the dissents in Dred Scott said that this violates natural law. The idea that an escaped slave has to be returned,
Right.
this violates natural law. So it's very interesting. Um, yeah, but the dissent did go on to say that, well, you know, although since it's been duly enacted, we still have to follow it, but it violates natural law. So let's talk about now parental rights. Um, this is the existence of a right of parents to dictate the upbringing of their children has been recognized, I think, for many, many years by the Supreme Court, and yet it's not mentioned in the Constitution as a right. And we talked a little bit before we started recording that, there are there were debates during the adoption of the Bill of Rights as to whether a Bill of Rights was even necessary or perhaps dangerous, because when you enumerate rights, then this could leave the impression that rights that you have not enumerated are not in fact rights. unless they've been enumerated, or else they would have been enumerated. And so this was one of the concerns that many people expressed. And it was, in fact, obvious to many people that there were rights that existed that were not being enumerated. And so you have the Ninth Amendment, which says essentially like that the fact that to paraphrase, the fact that we're enumerating certain rights here does not mean that there are not other rights that are retained by the people, so that's an interesting reminder of that fact. So presumably the right of parents to dictate the upbringing of their children is one of those rights that would come under or that was being mentioned by the Ninth Amendment. So can you talk a little bit, given that you've written books about this, can you talk a little bit about the notion of parental rights, what it means, and what is the basis for saying that it is a right that exists, even though it's not listed in the Constitution?
Right. So I think the basic notion of parental rights is an answer to the question, who has primary responsibility for and decision-making authority over children, right? The presumption being that children are children precisely because we call them children, right, rather than adults, precisely because they lack the maturity required to make decisions for themselves, right? And so, and to care for themselves and get what they need for their own survival and protection and so on. And so some adult or set of adults needs to both care for children, protect them, maintain them, educate them, and make decisions on their behalf, right? So
Right.
that's the kind of authority over children that's in question. And then the real question is, well, who is the primary authority over children? Is the primary authority the state, or is the primary authority the parents?
Mm-hmm.
And so to talk about parental rights is effectively to say the primary authority to make decisions on behalf of children belongs to parents, because the primary duty to care for children, which
Right.
includes making decisions on their behalf, belongs to parents. And that's
Right.
the vision of parental rights that you get throughout the tradition. It's all over Blackstone. It's in Kent when it comes to American law. You see it in Story. You see it all the way back to Aquinas and even
Yeah.
before.
So this is not something
So
invented by
this is not something
conservatives.
invented, right? And this is clearly presumed by, in a sense, the very notion of limited government, right? If you think, what does it mean to have a limited government, namely a government that is not totalitarian in its powers?
Right.
What it means to have a limited government effectively is to recognize that there are other sources of authority
Mm-hmm.
apart from the government. Um,
Right. Right.
and so, and primary among those is the family. So, recognizing that there is this community, this natural community that exists prior to the state, prior not necessarily historically,
Yeah.
right? I'm not weighing in
Chronologically.
on whether there
Yeah.
ever was a time when human beings
Yeah.
lived without political authority, but
Right.
simply prior morally, right? That even in the absence of any government, there would be families and there would be parents who have natural authority over their children because that authority is necessary to fulfill their child rearing responsibilities. Um, and that authority falls naturally to them, to the parents. Why? Because they are the ones who brought that child into the world, right? So there is this deep natural connection that obligates the parents to provide for the children that they brought into the world, and that, all else being equal, makes the parents the most suitable people to do that, right? There are natural bonds of affection that lead parents to be willing to make great sacrifices on behalf of their children. There's a natural alignment of interests where the parents want their children to do well and become mature, capable adults, in part because if they don't, the parents will continue to have to take care of them, uh, uh, indefinitely, right? Which most parents don't want to do. So there is that alignment of interests, even on a self-interested basis, why parents want their children to do well in life.
Yeah.
And then there's the fact that the it corresponds to the needs of children, which includes the psychological needs that children have to understand their origins, to know that they are loved by the people who brought them into the world, right? These are very deep human needs. And the best
Right.
way to kind of meet all of those needs is
Right.
for a child to be raised by that child's own natural parents. Obviously, there are cases where that's not possible,
Right.
or parents are not able to do that, and but that is the exceptional case
Right.
that, in a sense, proves the rule,
Right.
right? We don't think that parents should place a child for adoption for trivial reasons.
Right.
And we don't think that the state, at least most people, a few philosophers, but most people don't think that the state should step in and randomly assign children to parents, right, that
Right.
have been
Right.
line by the state. We
Yeah.
think that would be, a terrible
Dystopia or something.
dystopian, scenario, right? Why is that? Well, because we recognize that there is this natural connection um, between parents and children, and the state only steps in when something went wrong there. And then the state has to find some other parents to take over, right? And then you have the adoption process and so on
Right.
and so forth, right? But when there isn't such a rupture, when there are natural parents willing and able to raise their own children, there's no need for the state to enter, and the
Right.
parents simply take on the natural responsibilities that they have. And so, um, recognizing and respecting parental rights is simply recognizing that natural authority that the family unit has um, to govern its own internal affairs,
Right.
free from coercive state interference. Um, and that authority exists prior to the state, and it exists even within a political community. Now, obviously, the state has authority as well, because the state has a legitimate concern for the well-being of children and for the ordered
Right.
reproduction of society over time. But the state fulfills its concerns usually in a subsidiary way, right? We're back to the principle of subsidiarity, in a way that respects the primary child-rearing authority of parents, and then assists parents in fulfilling their duties
Right.
in ways that don't usurp parents' authority. So the state can um, help parents to educate their children by providing
Right.
free means for children to be educated, to ensure that everybody, including those who aren't wealthy, can get access to education for their children, right? The state can also be there in the background to protect children from abuse and neglect in these cases where the family,
Right.
radically fails to fulfill its function and so on. But again, that the state's role there should be kind of secondary,
Right.
stepping in when the family unit goes wrong, right? Cases of
Right.
abuse and neglect, and then helping parents to fulfill their duties, right? In ways that don't usurp the parents' authority. Now, how does the Constitution come in here?
Right.
So, as you say, there's nothing written about this in the Constitution. Um, Now, part of that is because at the founding, nobody would have even thought that the
Right.
government would enter this sphere, right? So
Right.
you have to think about the historical context. Why were the particular rights enumerated in the
Right.
Bill of Rights? Why were those rights written down?
Right.
Well, those rights were written down because those were the things that at the time of the founding, they had seen violations of those rights, right? By King George of England, or
Right.
um, by monarchs going beyond what they thought were the proper limits of government. And so they wanted to be explicit about rights that they thought the government was likely to interfere with. And
Right. I
that's
mean,
why
like,
they enumerated things like, freedom of speech and freedom of
yeah.
religion, the right to bear arms,
Yeah.
the
Or,
right
or,
not to have your home intruded upon by the military for
right.
quartering, right?
Yeah.
All
That was
these,
gonna say that. Yeah.
right. I
Yeah.
mean, so
Yeah.
basic things that were in their minds
Yeah.
because of the abuses that had happened around the time of the American
Hmm.
Revolution.
Right.
Nobody was thinking about violations of parental rights. Why? Well, because there was no pattern of government intrusion in
Mm.
family life.
Right.
And so they weren't even considering that a government would want to do that.
Right.
Um, so there was just a presumption there that that was a right that was going to be respected. It was part of the common law. It was well established. Nobody questioned it,
Right.
and so it didn't need to be written down, right?
Right.
And if
Right.
you again think about the 14th Amendment, which is what we're considering when we think about fundamental rights applied against the states. I mean, people often forget that the original Bill of Rights was a set of rights limiting um, the federal government.
Right.
That the original Bill of Rights did not limit the state governments.
Hmm.
And one of the reasons why, I mean, just a tangent, but I think it's worth pointing out, people often forget this, that one of the reasons why Madison worried about having an enumerated Bill of Rights was that not only would it lead people to think or to kind of disparage other rights that were not enumerated, but would also lead people to think erroneously that the federal government has the power to do everything except what the Bill of Rights forbids. But of course,
Yeah.
that's not the design of the federal government. The federal
Right.
government is not a government of general jurisdiction.
Right.
The federal government is a government of delegated and enumerated powers. In other words, the federal government only has the power to do that which is explicitly
Right.
granted in the
Right.
Constitution. And this is different from state governments, which are governments of general jurisdiction, exercising general police powers for the public welfare, right? And so it actually makes more sense for state governments to have bills of rights, because
Right.
state legislatures effectively can do whatever they think is reasonably related to the public welfare,
Yeah.
whereas that's not the federal government.
Mm.
The federal government can only do very limited things.
Yeah.
And so Madison thought it was actually going to be miseducational to have this Bill of Rights, because why would the federal government, which according to the Constitution basically can only, regulate commerce
Right.
and, you know, um,
Yeah.
engage in peace treaties and declare war with foreign nations, and very limited
Yeah.
set of things.
Yeah.
Why would you need this Bill of Rights when you have this very limited set of
Wow.
government powers?
Yeah. Yeah.
And in a way, Madison was prescient, right? Because you
Yeah.
see, in fact, most
Yeah.
people don't even recognize that the federal government is limited in the way that I just said.
That's
They think
right.
it
Yeah.
has the same general jurisdiction that states do.
Hmm.
And the Bill of Rights, I think, is part of what leads to that. I mean, that's complicated. But
Right.
um, anyway, back to parental rights. So the 14th Amendment, which is what actually applies to the states and
Right.
limits the states, says that it effectively echoes the Fifth Amendment of the
Right.
Bill of Rights, saying that no one shall be deprived of life, liberty, or property without due process of law. No one shall be denied the equal protection of the laws. And then there's the Privileges or Immunities Clause. Um, uh, the privileges or immunities of the citizens of the United States shall not be abridged, right? And then
Right.
it gives Congress the right to enforce this against the state, right? So there's a
Right.
kind of federal supremacy over and against state laws for any laws that the state might enact that would be contrary to these provisions of the
Mhm.
14th Amendment. And again, the context here is the context of recently freed slaves and
Mhm.
wanting to ensure that they receive the equal protection of the laws,
Right.
um, and that their rights are not denied simply because of their status as previous uh,
Right.
slaves, right? And so that's what's happening in the 14th Amendment. And then an originalist is going to want to say, well, among these kind of broad privileges or immunities of the citizens of the United States, or if you think that there's substantive rights implicit in the due process clause, among those substantive rights, well, what would have been recognized as such at the time of the ratification of the 14th Amendment around 1868? Would parental rights have been recognized there? And I think the answer to that is obviously yes, right? Because of the very strong common law tradition of protections for parental rights. There are a number of state Supreme Court cases um, shortly after the time of the 14th Amendment, as the common school movement is um, starting to become more popular, and you see more of these common schools present and educating students, and then compulsory education laws being enacted in
Right.
various states, there are a number of cases in the mid to late 19th and then early 20th century where parents want to avail themselves of the free common school education, but they don't want their child to take every class for
Right.
whatever reason. And there are a variety of reasons that come up in these cases. Sometimes it's just, I think my child has better things to do than to take the singing
Right.
class or whatever. Um, and there are 8 such cases. In 7 out of 8 such cases, state Supreme Courts from various states decided on behalf of the parents, arguing on the basis of common law that because parents have primary educational authority over their children, and because the state's role is secondary, right? The state in providing the common schools is simply meant to assist parents in fulfilling their duties. And even when enacting compulsory education laws, the state's not taking over education, it's simply enforcing the duties that parents already have by nature and making sure that they fulfill those duties up to a certain minimum level. Um, and so the courts there are arguing that because of parents' prior educational authority, because parents know better than the state what's in their children's best interests and how best to educate their children, and are better motivated than any state official to want what's in the best interest of children, that the state should defer to parents. And as long as it's compatible with the discipline and efficiency of the school, they should allow the parents to opt their children out of whatever it is in the school that they don't want the child um,
Mhm.
to learn. And that again gives you a very strong sense of, even within the public schools, the idea that parents have primary educational authority, and that was the common law understanding around the time of the ratification. And the
Mhm.
enactment of compulsory education laws and so on don't change that. And then the Supreme Court doesn't weigh in on this, as you say, until much
Mhm.
later. The most important, 2 cases are Meyer versus Nebraska in 1923, and then Pierce versus Society of Sisters in 1925. And what those 2 cases do, in effect, together, I think, is to declare that the common law protections for parental rights in education and in general, for the right of parents to direct the upbringing and education of their child, um, that common law right of parents is declared to be part of the liberty protected by the 14th Amendment. That, I think, is what
Mhm.
is happening in Meyer and Pierce. So they're not inventing this right out of whole cloth. They're simply saying, um, we recognize that there are certain rights that are basic, that are implicit in the constitutional order that the 14th Amendment is protecting. They root this in the Due Process Clause. Again, one could just as easily root it in the Privileges or Immunities Clause, or even in the Ninth Amendment. Um, but either way, you would get basically the same idea, which is
Right.
that any of these clauses would protect the basic common law rights that were understood to be fundamental at the time of the ratification of the 14th Amendment. And
I
parental
see.
rights was clearly among those rights.
Okay, so we've seen you talked about it's easy to see why the education context has become so salient in the argument over parental rights. Um, Now, let's look at the other side. The other side being, I guess, schools who are saying, um, uh, in fact, parents don't have a right to opt their children out of the. Are these schools? I mean, are these let's say parties to this litigation that is starting to bubble up? Um, are they arguing that there is no such thing as parental rights, or are they just simply arguing that, for example, assuming that there is parental rights, that the government's interest doesn't have to be of, of such a high level nature to intrude on this right, and that, or are they arguing that the government does have, yes, okay, there are parental rights, but the government does have, this very, very strong, like overriding interest in, making sure that kids learn about, for example, that the two people of the same sex can get married, that is analogous to making sure that a kid gets treatment for leukemia, for example, where obviously the state does have an interest in overriding any parental objection to such medical treatment.
Right. So I think, there's a long history here. I think what is often happening in these cases is a couple of things. So number one, um, the Supreme Court cases that recognize parental rights as fundamental constitutional rights, Meyer and Pierce, are very old, right? 1923, 1925. The style of the way opinions were written at that time, very broad brush, pretty brief, very brief compared with contemporary opinions. And so there wasn't a lot. Now I think there's a lot in there, and I think in fact you can spell out with some specificity what's being protected.
Mm-hmm.
And I have some articles coming out trying to do that,
Yeah.
but nonetheless, it's pretty broad brush. And the Supreme Court has not really weighed in any significant way with regularity on these matters. So, I mean, the next major case regarding parental rights in education specifically that the Supreme Court took was Wisconsin v. Yoder in the 70s.
Right. So
Right.
talk
So
about
that's
Yoder. Yeah.
that's half a century
Right.
after Pierce and Meyer. And it was a very specific idiosyncratic sort of case in the sense that you're dealing with the Amish, which are a very unique, fairly isolated, and small minority community. And in that case, the primary right being discussed was religious freedom. So
Right.
parental rights came in, but religious freedom was really the primary emphasis of the arguments and
Mm-hmm.
of the opinion. Um, so that was a case in brief where the Amish wanted to exempt their children from Wisconsin's compulsory education law after the 8th grade. They said, we're okay having our kids go to standard schools
Right.
until 8th grade, but after that, we want to educate them at home in the Amish way of life. And so we want to be exempted from basically the last 2 years of the compulsory education
Mm-hmm.
requirement. And the Supreme Court granted them the exemption. They argued that they had a constitutional right to that exemption. Um, and the argument was, look, you have both a strong free exercise right. This is a strong element of the free exercise of their religion.
Mm-hmm.
And you have a right of parents to direct the child's education and upbringing, and that together you get a very strong fundamental right because these two things are connected, right? It's a kind of
Mm-hmm.
later referred to as a hybrid rights case where you have
Hybrid,
two
right? Yeah.
rights. And because it was both of these rights, they applied what's called strict scrutiny, namely the highest standard of judicial review, where the burden of proof is shifted to the government to have to defend its law, and it has to defend its law by saying that the law is not just reasonably related to some legitimate interest, but narrowly tailored to a compelling interest. So it's the least restrictive means to an interest that is compelling,
Right.
necessary for that compelling interest. And on that
Right.
standard, the court said, no, I mean,
It's
you can
yeah.
clearly opt the Amish out of the last 2 years of compulsory education without undermining the basic state interest in making sure the children receive an education sufficient to be law-abiding, productive
Mm-hmm.
citizens, right? The Amish have a
Right.
long history of, not being a burden on the state, of being self-sufficient, of educating children on their own to be
Right.
law-abiding, mature, self-sufficient adults. So the
Right.
state interest in this instance can be met without enforcing this compulsory education law all the way up to
Right.
the 10th grade for the Amish. The problem is that because that was a very unique case, um, there was a tendency afterward to um,
Limit.
then limit what parental rights alone could get you.
Mm-hmm.
Also because, I think this is just a kind of way in which our system works, is that judges like clarity and litigators like clarity. So, litigators are going to brief the arguments that are most likely to win. And those are going to be arguments where there's well-established precedent on your side, or you can at least make that case. And because the precedents were so in a sense, foggy when it comes to parental rights.
Hmm.
Litigators tended to emphasize free exercise claims,
Right, right,
um, which looked like they had more promise
right,
because the First Amendment explicitly mentions free exercise of
right,
religion, and so there's a stronger anchor there. There's
right,
the court has taken many more cases on religion, and so there's a lot more precedent to go
right,
with. And then judges themselves prefer to adjudicate on grounds where they can cite lots of clear precedent and things like that.
right.
So what happens is that in a lot of subsequent cases where you're dealing with disputes between parents and the public schools, um, the parental rights aspect of the case tends to get downplayed or interpreted very weakly and
Mm.
narrowly. So you have, I mean, I think the the most kind of bald-faced instance of this would be, Fields v. Palmdale, where the Ninth Circuit said, parental rights don't extend beyond the threshold of the schoolhouse door. They did
Oh, wow.
later amend that because
Yeah,
even for the Ninth Circuit, that sounded too
yeah.
strong. But the basic point was not changed. I mean, the basic idea was
Yeah,
Meyer and Pierce, and Pierce in particular, say, okay, the government can't force you to send your child to a public school.
right.
But beyond that, that's it. If you
Yeah,
choose to send your child to a public school, and choose, I mean, in quotation marks, because of course, for
yeah.
many
Many
for
people don't
many
have
parents, that's
options.
the
Yeah,
only option because they can't afford anything else. But
right.
but choose. That's sufficient
Yeah.
on they're saying. Um, if you do that, then you have no rights beyond that, right? Now that I think is clearly not what Pierce meant or what
Hmm.
Meyer meant, but it's been interpreted in this narrow way. Um, I think as a kind of default due to the confusion about the scope and the strength of parental rights, given
Yeah.
the paucity of case law and precedent on this matter, at least at the Supreme Court level.
Actually, you just reminded me of 303 Creative, where, the others, this is the case where the lady who made the websites for marriages, and she didn't want to make the websites for same-sex marriages because it was against her religion and was running afoul, according to the of state anti-discrimination laws. And I remember the other side was saying, well, she's choosing to enter the marketplace.
Right.
It's like, well,
Right.
yeah, but I mean, that's part of like public life. You know what I mean?
Right.
Like, I'm not really,
You don't really have much of a
you
choice
don't have
there
much of a choice. I mean,
to
that's
make a
what
living, right?
to
So
make a living.
yeah,
That's what I
yeah.
do. So, so it's kind of like, and the court didn't buy that. So I wonder if that, foreshadows. And not only that, the court also in that case said, well, yes, when it comes to the issue of strict scrutiny, I mean, the court was like, it's not a compelling interest to make sure that, yeah, I mean, the court acknowledged that, okay, yes, the government does have an interest in making sure that people don't discriminate, but it's not a compelling interest in at least when it came to that particular, um, you know, like the sort of the dignitary rights kind of thing, um, as distinguished from something like kind of the right to go to a hotel of your choosing, regardless, even if someone doesn't like your race, a little bit different. From that, it's just sort of a dignitary right, like, well, the right not to be offended. So the court said that there was no compelling government interest there. I don't know whether there's any sort of relationship between that and this other. So, but well, there is kind of, because one of the arguments that these school boards are making is that we have a compelling interest in making sure that children are respectful of the fact that that other that there are families where there are two husbands, for example. So it seems to me that it's kind of like, okay, well, even if that is even if the government does have an interest in such a thing, is it a compelling interest that make sure that these kids are hold the opinions that government, you members of the school board hold. It seems to me that like an argument would be, well, um, even if there is such a government interest, it's not a compelling interest. But that leads to the question of, um, maybe this is not necessarily pertinent, but are fundamental rights always, um, are they, is it always the case that they can only be um, infringed on when there's a compelling government interest, and it's narrowly tailored? Or are there fundamental rights that, where there only need to be like a reasonable basis for their infringement?
If it's a fundamental constitutional right,
Right.
the correct standard of review is strict scrutiny. And
I
so,
see. Okay.
yeah,
I see.
so there would have to be a compelling state interest,
Right.
and the
Yeah.
law would have to be narrowly tailored to that
Yeah.
interest.
Interesting. So let me, we'll wrap up here by asking, are you tracking any cases or looking at any specific, by the nature of your work, you you look at things at a very high level, but have you noticed any particular cases bubbling up that might be occasions for the Supreme Court to clarify the scope of parental rights? Or is it the case, and you mentioned that, well, litigators are often kind of, looking for the path of least resistance, or the low-hanging fruit, as it were. I think in the Mahmoud versus Taylor, which is this case out of Montgomery County, which a lot of people have been watching, Montgomery County, Maryland. I think even in their, I might be wrong here, but I think even in their cert petition, they limited it to free
You don't brief
exercise.
parental rights. There's
Yeah,
a
yeah,
footnote. There's a
yeah,
footnote where they say, well, of course, religious freedom and parental rights are connected. So,
right, right, yeah,
but they don't really brief the parental
right,
rights issue, which I think is a shame. But again, it makes sense.
yeah, yeah,
Um,
yeah,
they think they have a stronger case in terms of, likelihood of winning,
right,
um,
right,
if they
right,
focus on religious freedom. And I think religious freedom is sufficient
yeah, yeah, yeah,
to
yeah,
win the case.
yeah, yeah,
And they don't want to muddy the waters, perhaps, by
right,
bringing in a less
yeah,
established right.
yeah, yeah,
Um, so I understand that in terms of litigation
yeah,
strategy, but it
strategy.
does seem like a missed opportunity to clarify the scope
Yeah,
and strength of parental rights. But I do think there are other opportunities in the pipeline. Now, of course, it all depends on whether they make their way up
right,
um,
right,
the various levels of appeal, and then whether the Supreme Court, grants the cert petition or not. I think it was a shame that in the Eau Claire case,
yeah,
the Supreme Court passed up an opportunity to clarify
mm-hmm,
parental rights there. I mean, several of the justices indicated that they thought they ought to have
yeah,
taken the case, but there will be others coming in with, I think, an even better fact pattern.
yeah, yeah,
Um,
yeah,
so I mean, so that was a case, and one of many such cases kind of percolating right through the
yeah,
various levels of the
yeah,
courts regarding what you might call secret gender transition policies that
right,
are increasingly common in public schools, where the schools have an official or unofficial policy of taking children who express confusion about their gender, and then encouraging or allowing that child to transition to a different gender in
right,
school, different name, different pronouns, change of clothes, different
right,
bathrooms, locker room,
yeah,
sports teams,
E-
right? Everything,
yeah.
uh, field trips, right?
Field trips, I
Everything
was
that
gonna
goes
say,
with that.
even, yeah, even
Um,
going on field trips,
even going
yeah,
on field trips, and
yeah,
rooming with people of
rooming,
the
yeah,
opposite sex but same gender identity, right?
yeah,
And doing all of this without even informing the parents. In fact, taking explicit steps to hide this from parents by, for instance, using the given, official name and so on any documents that go home to the parents,
right,
and making sure that they don't see any documents that indicate, the new gender and so on, that are
right,
being used for the child in school. And eventually this gets out, right? It's almost inevitable.
yeah,
But in the
yeah,
meantime, it could be a while, and harm can be done to the child. And so the Eau Claire case was a case that was, in a sense, parents expressing concern simply about the existence of the policy
Right.
and saying the policy itself is an infringement on our parental rights. And I think there's a strong
Right.
case for that.
Right.
But the reason why cert was denied there was they said, well, you don't, there's really no injury yet because
Right.
you haven't shown that your child has indicated any confusion about gender and that therefore your child won't be affected by the policy. Now, I think
Right.
that's kind of
Yeah.
sophistical,
Yeah.
but there is another case making its way through the pipeline where the child was
Oh,
transitioned to another gender in the school.
yeah. Oh,
And
wow.
then after the fact, the parent found out, and so the harm
Yeah.
had been done. And so the standing issue is much clearer there. Um, and that's one that's coming up through New York.
Oh, I
Um,
see. I see.
yeah,
Yeah.
Vitsatsaki, a hard to pronounce case name.
I'm not
Um,
even that wasn't even on my radar. That's great. Thank you.
yeah, I
Yeah,
mean
for the yeah.
it's in the early stages
Yeah.
yet. So still going at the district court
Yeah.
level.
The
Um,
the last question I'll ask is w- uh if the Supreme Court takes up a case to and clarifies parental rights in the education context, would that also, I mean, of course, the issue of parental rights also comes up in the medical care context and custody and that sort of thing. Is it likely that a decision in the education context would also, clarify those rights for these other contexts as well?
it might help. I think actually, although none of these contexts is perfect, but
Yeah.
there's actually more precedent and better precedent
Mm.
on the medical care
Okay.
context and the custody context.
Okay.
Because you have more cases on those grounds, and courts tend to be more deferential to parents, at least in
Uh,
some instances there. So, like
yeah.
especially on custody, I don't think you have quite enough, but you have Santosky v. Kramer, for instance, um, where where the court has a kind of high standard, not quite the highest standard. I think it probably ought to be the highest, but nonetheless high standard for
Yeah.
determining a parent to be unfit and for the termination of parental rights. Um, I think more needs to be done to ensure full due process rights for parents with child protective services
Right.
investigations
Yeah.
against them, right? I mean, I think given the enormity of what's going on, right? You're trying to
Yeah.
separate a child from the
Right.
parents and ultimately even, perhaps terminate parental rights permanently.
Right.
Um, the idea that you wouldn't require court appointed counsel on
Right.
behalf of the parents, right? And that
Yeah.
parents have to pay for counsel out of pocket.
Right.
And most of the time, these are very poor parents who can't afford a half decent lawyer.
Anyway.
Right,
Yeah.
right. So, I mean, I think a lot more needs to be done in terms of due process protections for parents
Oh,
with child
sorry.
abuse or neglect allegations, including the right to a lawyer and things like that. But nonetheless, the precedents there are actually better. Um,
Right.
Likewise, in the medical context, again, at least when it gets to higher levels, the precedents are better. I mean, at lower court levels, sometimes children get taken away very easily and um, without warrant in cases where there's just a kind of suspicion on the part of a doctor, even if you have some other doctor that
Right.
agrees with the parents, or the parents just
Right.
want a second opinion, but courts will often just swoop right in, take the
Yeah.
child away even before they've looked and said, look, there's a case of conflicting medical opinion here. So, those things happen, but typically at lower court levels, kind of family
It's
court levels, not at appellate court levels.
it's interesting that people who would be tend to be of like a progressive political bent would kind of sympathize with or see see the reasonableness of requiring more scrutiny in those kind of cases than they would in the school context. So maybe that's an opportunity for people of all political views to come to some common ground, and then from there move on to say, all right, well, then how does, if we accept that there is such a thing as parental rights and that, it has this scope, how does that then apply in another context where you might politically, have a different point of view.
Right. Um,
Yeah.
one thing I should add, though, even in the education context, I think if the court is given the opportunity to actually look at parental rights. I think that if the court follows through on its preferred method, namely to look at history and tradition in order
Right.
to determine whether the right is genuine, and also to determine the scope and strength of the right, then I think we can hope for a clarification and strengthening of parental
Okay.
rights from this court. Because if you do look at the Pierce and Meyer decisions themselves, and then at the common law tradition that they were declaring to be part of the 14th Amendment,
Right.
and some of the common law state Supreme Court decisions on parental rights and education, what you find there is an implicit application of strict scrutiny. And they didn't have the doctrine of peers of scrutiny at that point, so they're not going to use that
Right.
language. But
Right.
what you have is, in fact, what we would
Yeah.
today call strict scrutiny, that they were
Right.
putting the burden of proof on the state,
Right.
requiring the state's policy to be narrowly tailored, and so on, and that the laws were overturned precisely because it didn't meet that very
It didn't
heightened
meet that.
standard of review. Because on a rational
Right.
basis test, the laws at issue in Meyer and Pierce would have survived.
Right. Yeah,
Right.
that's a very good point. Yeah.
So strict scrutiny was implicitly being applied there.
Yeah.
And
Yeah.
if you think about the scope of parental rights and education, again, the common law tradition and the text of Pierce gives you a broad scope that clearly extends beyond the threshold of the schoolhouse door.
Right.
Where as long as it's compatible with the schools, being able to operate with reasonable efficiency, they should try to accommodate
Yeah.
parents who
Yeah.
have objections to certain aspects of the curriculum.
Wow.
And given the things schools already do, right? You have individual education programs
Right.
for children. You have special gifted
Right.
programs. You
Right.
have
Yeah.
all
Sports.
sorts of
Yeah.
individualized things.
Yeah.
The idea that you might opt a child out of a class dealing with controversial issues or something, it's just, I mean, they should be willing to do that.
Yeah.
To do at least as much as they do for disabled or special needs or gifted children,
Right. Yeah.
in order to uphold parental rights. So yes, I think a much broader scope for parental rights, even within the public schools. And then frankly, even, I mean, this, I don't know whether the courts will go for it. I think it's a strong argument that can be made on a mix of free exercise and parental rights grounds, that even the current state in which the public schools have a monopoly on public educational funding
Right. Right.
is
Exactly.
unconstitutional.
Yeah. That's a good
Because
point.
it's effectively coercing parents
Yeah.
coercing parents who lack the means to send their child to a private school, which many
Yeah.
parents fall in that boat. It's coercing them to send them to the public school, and so to be exposed to the state's preferred educational messages, which at least today are not religiously neutral, right? They tend to align with what you might call theologically progressive viewpoints,
Right.
and so they
Right.
run afoul of the Establishment Clause. They run afoul of free exercise, because if you think
Right.
about, non-religious parents, they can send a child to the public school, which is non-religious,
Right.
and so
Right.
they have an ability to, right? But religious parents have to choose
Right.
between foregoing a very important public benefit of free education or failing to educate their children in line with their religious beliefs.
Right. And you still have to pay
and the
property
courts
tax.
have already said
Yeah.
that you cannot place an unconstitutional condition on the free exercise of religion in that way, even when it comes to simply acceptance of a benefit, right? Cases
Right.
in Espinoza and so on. So I think strong arguments could be made on those grounds for
Yeah.
something like a universal school choice requirement, which
Wow.
would take a lot of pressure off of public schools and the curriculum wars issue, because then everybody would have a real exit
Yeah.
opportunity.
Yeah, I mean, speaking of litigation strategy, I think, maybe something to think about is that those who are advocates for for parents in these kind of situations should take a longer view and say, well, this immediate case, I might need to take this strategy, but for a broader looking down the road, maybe I should should be briefing parental rights instead of simply free exercise. But on the other hand,
Right.
then we have the lawyers have a duty to their specific client at that time to make
Right.
the most winning argument. So it's a tough situation.
Yes, they're
Well,
in a tough situation.
well, thank you so much. This has really been fascinating. I appreciate it. I have another maybe hour or two of questions to ask you, but we'll have to leave it there.
I think we've already taxed our viewers enough. So
Yes, no doubt, no doubt. And if you're still with us, congratulations. And no, but thank you, Professor Moschella, so much, and I really appreciate you giving us your time today.
my pleasure.
Thank you.